Am I audible?
Yes, ma'am, you are audible.
Clearly audible, ma'am.
Clearly audible.
Assalamu alaikum, ma'am.
वालेकुम अस्सलाम।
आप ताहिरा मैम है, आप प्रैक्टिसिंग एडवोकेट है इलाहाबाद हाई कोर्ट, और ये आज हमारी पैनलिस्ट है। बाकी मानवेंद्र की ऑन करना। मानवेंद्र, आप स्टार्ट कर सकते हैं अपना वॉइस।
Yes, ma'am. Am I audible, ma'am?
हाँ, you are audible.
Yes, ma'am.
मानवेंद्र, आपने LLB किया है 2018 में, right?
Yes, ma'am.
And since then you are preparing for judicial service examination?
Yes, ma'am. Ma'am, in between that period, I was also practicing from 2018 May till 2019 December. I was practicing in Delhi, ma'am. And after that, my full-fledged preparation started.
What do you mean by ICJ?
ICJ, sir. Sir, ICJ stands for International Court of Justice, sir. It is one of the permanent organs of the UN, sir, United Nations, which deals with the.
From India has been elevated to ICJ.
I'm sorry, sir. Your voice is not. So, can I use earphones, sir? So that...
Sure, you can use your phone.
Yes, I am hearing. Are you hearing us?
Yes, sir. The voice is audible, sir.
One gentleman from Bihar has been elevated to ICJ. Can you name?
Sir, if I'm not wrong, Mr. Manvendra Singh was from Bihar, and he was elevated to ICJ, sir.
Is there any person in ICJ at present from India?
Yes, sir. Honorable Justice Mr. Dalveer Bhandari is representing India, and he's right now, sir, in ICJ.
Who can withdraw the prosecution? Criminal prosecution under under the provisions of CRPC.
Yes, sir. Withdrawal of prosecution is being given. The power of withdrawal of prosecution is being given to the state government. If state government is of the opinion that the case is not of a serious nature, then, sir, state government can withdraw the prosecution.
Is the court bound? Suppose the prosecution made a request for withdrawal of the case. Is the court bound to withdraw?
No, sir. Sir, it is the prerogative of the court. Rather, it is a discretion of the court. If the court is of the opinion that the matter will not cause serious injury to the society, or the matter is of such nature that withdrawal will lead to serious injury to the parties or the victim, sir, then in those circumstances it will not allow the withdrawal of the case, sir.
How the pardon is granted under CRPC?
Yes, sir. Sir, pardon is being granted under two mechanisms, sir. Under 306 and 307 of the Criminal Procedure Code. Under 306, sir, Chief Metropolitan Magistrate and Metropolitan Magistrate may pardon an accused at the stage of investigation, inquiry, and trial. And under 307, sir, any Chief Judicial Magistrate of first class has been empowered to pardon an accused at the stage of inquiry and trial, sir. This is the fundamental difference between those.
What are the main conditions? Suppose a person has been granted pardon, and
yes, sir,
later on he violates the condition of pardon, then
yes,
what
sir.
can be done?
Yes, sir. Sir, in those circumstances, he will be charged for the offense with which he was earlier charged, and also with the offense of fabricating and evidence and manipulating the court. Sir, both these offenses will be tried upon him, sir. And if I'm not wrong, sir, am I allowed to take a guess as per the section? I guess it is under section 308, sir.
Is there any provision under CRPC with regard to the admission denial of the documents filed by the prosecution?
Admission, sir. I'm sorry, sir. I'm right now not able to memorize that.
What is difference between the rejection of the plaint and return of the plaint?
Yes, sir. Sir, there are several grounds mentioned for the rejection of the plaint, under which, sir, if the plaint does not disclose its cause of action, if the sufficient amount of court fees is not paid, or several other grounds, sir, the court can reject the plaint prima facie, sir. However, sir, if plaint is rejected, then the plaintiff or the party whose plaint is rejected will be at liberty to bring a fresh plaint on the same cause, on the same grounds, because the case was not heard on the merits of the case.
What
However,
are the
sir,
interrogatories?
and
What are the interrogatories?
Yes, sir. Interrogatories are form of question and answer. Yes, sir. Interrogatories are form of question and answer which are being issued by the court to the party, to the other party at the request of the one of the parties to answer or to produce any documents. Sir.
Suppose a person performed puja in a temple, but the pujari or the governing body of that temple not allowed that person to perform puja there. What is the remedy that person is having?
Sir,
And
although
under
religious
which
matters,
provision of law?
yes, sir. I'm sorry, sir. Sir, although religious matters completely do not fall under the civil nature of the cases, however, when religious matters, when attached with the political, with the civil rights as well, in this case, sir, as you said, if he is not allowed, then in those circumstances, his civil right is also violated, then he may institute a suit under Section 9 of the CPC.
A person want to file appeal against the judgment, can he file?
A person wants to file a case, appeal against
a judgment.
Sir, with my little knowledge, I guess, sir, he can definitely file an appeal against judgment, sir.
Whether appeal lies against a decree or a judgment?
Yes, sir, I'm extremely sorry, sir. An appeal, a decree is always appealable, sir, under Section 96(2) of Civil Procedure Code says, sir. The decree is always appealable, sir.
How many type of mortgages are there?
Sir, under Transfer of Property Act, 6 types of mortgages are preferred.
Suppose
Simple mortgage.
I'm cutting short. Suppose a mortgage which doesn't fall in any category, under which category it will be covered?
Sir, under the category of anomalous mortgage, sir.
A person is making a contract on telephone. One is sitting in Delhi, another is sitting in Bihar. Where and at what time the acceptance will be deemed to be completed?
So where the acceptance is made and clearly heard by the party at that place, it will be deemed that the contract has happened at that place.
What is a special leave petition?
Sir, special leave petition, as provided under Article 136 of the Constitution, is a power which is being granted to the Honorable Supreme Court of India to allow any appeal from any order, decree, judgment, or any other order as well, which involves a substantial question of this.
What is defense of insanity?
Defense of insanity. Yes, sir. Yes, sir. Sir, under IPC, sir, defense of insanity can be, sir, legal insanity particularly is adopted by the Indian legal system, which says that at the time of committing offense, if the person is not able to evaluate his actions, then...
Can you tell me something about the McNaughton test?
McNaughton's principle, yes, ma'am. In the McNaughton's principle, 5 principles were laid down in the McNaughton case, and the 3rd principle was adopted by the Indian legislature, which lays down the rule of.
Can you define that where in the Indian Penal Code the test, heckling test is given? Under what provision we deal with the heckling test?
Under provision 292, ma'am, it deals with the prospect of obscenity. And,
what was your optional subject in the exam? What subject you choose?
Ma'am, my option. Yes, ma'am. My first option was Constitution and Administrative Law. My second option was transfer of property, trust and specific relief, and my third option was contract and torts.
Okay. Tahira ma'am, you can ask.
Manvin, can you hear me?
Yes, ma'am. Yes, ma'am.
Yes. You have given enough answers on legal side. What I would like to know from you is, what is your take on media trial? What do you understand when we use this word media trial? And please give me example of some recent case and tell me what is your take on this.
Yes, ma'am. Ma'am, under the legal justice system of India, it has been well drafted to meet the needs of the parties and to keep the parties intact within the legal sphere, so that the identity of the party and before the trial, their there is no prejudice actually being caused to them. When media trial is one of the trial when before the case is being heard or by the court competent to adjudicate it, the media creates a perception about that person and prejudices the case, and media trial indirectly also reflects or also creates a perception in the court's mind. So, ma'am, in my opinion, ma'am, such trial should be regulated by a well-defined clause.
My next question would be, what do you understand by doctrine of laches?
Doctrine of laches means when there is it is basically upon the delay principle. When there is a petition which is to be filed or an application which is to be filed, or there is a reply which is being given in any trial or suit or even in civil or criminal cases. And when there is a defense which is being claimed by the plaintiff, that is a delay or lashes. It can be termed as unavoidable circumstances due to which a person is not able to file his written statement or reply or anything of that nature.
And what can you tell me about, one last question from my side.
Yes,
What can you tell me about separation of power?
Ma'am, under the scheme of the Indian Constitution, the separation of power has been well provided from Article 245 to Article 254, ma'am, in which both the center and the state has been made superior in their respective fields, ma'am. And this power specifically has been divided into three lists, ma'am, that is union, concurrent, and the state list, and everything all these state government as well as union government is made superior to enact laws in their respective fields.
Can a court pronounce the judgment in terms of the provisions enshrined under Order 10, Rule 1 CPC?
Sir, I'm sorry, sir, I'm not able to recall at this point. I know the provision of Order 10, but I'm not able to specifically deal with your questions. I'm sorry.
All right. What is the difference between evidentiary admission and judicial admission?
So, judicial admission is such which is made before the magistrate. And, sir, if my so, sir, can you please repeat your question once, sir?
What is the difference between evidentiary admission and judicial admission?
Sir, evidentiary value of admission is that it is not a substantive piece of evidence. However, it may operate as a estoppel as defined in the Section 31 of the Evidence Act. Sir, but sir, this is.
Can a court pronounce the judgment in terms of the Order 12, Rule 6 CPC?
I'm sorry, sir. I'm extremely sorry.
What is the mandate of Section 58 of Evidence Act?
Sir, Section 58 of Evidence says that admitted facts need not be proved. It dispenses with the burden of proof on the party to prove a fact. It is presumed that the court will assume those facts to be true.
So, Manvendra, what is the meaning of white collar crime?
Sir, a white collar crime of financial crimes or corporate crimes which are being committed by the persons who are in the higher position of any entity or any corporation, and when those crimes are being committed, then it is called white collar.
Manvendra, we would like to take 2 minutes of yours and we'll give you the review
Yes,
in 1 minute. We are supposed to mute our mic. You are not supposed to.
No, यही दे देते हैं. In our opinion, you will be selected. Your confidence level is good. Your command on language is good. You have very good knowledge of law, and you are also straightforward. When you don't know anything, you are saying no. You keep it. But with regard to you have good sense of dress. Your coat and shirt tallies with having good matching, but you should wear tie.
Yes, sir.
That is the
Yes,
only.
sir. Yes, sir.
That is the only thing lacking.
Yes, sir. Yes, sir. Yes, sir. Sir, I'm supposed to buy a new suit, sir. It is getting delayed day by day, sir. I'll buy it day after day.
In our opinion, you should be selected.
Thank you so much, sir.
Okay.
There were a few questions which I was. There were a few questions which I was not able to answer, sir. Sir, only one question that I want to ask, sir, regarding that evidentiary admission and judicial admission, sir. This is one of the aspects which I'm completely
is basically during the course of trial. You have to prove certain things, and during the trial, something is admitted, then that can be termed as evidentiary admission. For that, you have to prove it. But judicial admissions are based on the pleadings.
Yes.
Something admitted in the pleading, and it is a judicial admission.
Judicial admission. Yes, sir.
You will be selected.
Okay, sir.
Rest assured.
Rest assured.
Thank you so much.
Good luck.
Very good luck ahead.
All the best.
Okay, thank you so much. Thank you. Thank you, ma'am. Thank you so much.